The Gauteng provincial government has taken up the cause of justice for a 2-month-old rape victim. Social Development MEC Nandi Mayatula Khoza has outlined plans to get justice for the South African-born Mozambican toddler. The Department of Social Development is now pursuing Baby M's alleged rapist, believed to be her biological father. Baby M's mother was sentenced to life behind bars last month for shielding her rapist from prosecution. Last week, the department brought Baby M from Mozambique and placed her in protective custody through a court order.
The Department of Social Development is still pushing for further justice for Baby M, even after its mother was convicted last month and sent to jail for life for her role in the baby's rape. And I think at this point I must express my appreciation to members of the media who brought this story to the attention of the Department of Social Development, because I only heard about it this year, and also my officials heard about it this year, whereas it happened in 2016. But I do want to say thank you to the journalists who really picked it up, and we were able to pick it up from the media ourselves.
Now joining us on this very story is Ntabiseng Mohale, Commissioner at the Commission for Gender Equality. Mayor, thank you very much for your time. I mean, this story has got to be the most disturbing story we've heard of the brutalization, the rape of a 2-month-old child. It's beyond disturbing. What is your take of, or at least the manner in which it has been handled thus far?
It's actually absolutely gut-wrenching. It is the saddest thing one can actually hear in the news. I actually think the court has not handled it well in terms of the outcome. However, I also think we as the public do not understand certain of the facts that the court considered in making its decision. I believe that if the father of the baby was a primary caregiver just like the mother, the court should actually have considered a similar sentence for the father, not as a rapist, but as an accomplice, because this is what the court considered in this instance. I believe the court used the Sexual Offences and Related Matters Act of 2007, which is a very broad and progressive piece of legislation that talks not only about the one person or the people who rape, but rather even those who are around and enable that to happen. But it's not only rape, it's broadly a crime, being an accomplice. But this act particularly expresses it. That
it honestly was interesting. I mean, even the Social Development Department was a bit concerned that here you have a situation where it said both parents were present when the child was hurt, if nothing else, because the father was saying we were in a scuffle of some sort and then the mother fell on the child. But then somehow, if both were present when the child got hurt, according to them, why only is then one charged?
Yes, but you need to remember that the parents went to the medical to the doctors and said, we were there when the child was hurt. And then it was only after they made thorough tests that they actually realized that not only is the baby hurt, but the baby has actually been raped. So I don't know the proximity of the father at that time, but the mother as a primary caregiver then has to know what has happened. And the South African law, fortunately or unfortunately, does sentence an accomplice on an equal footing as the primary perpetrator of a crime. And I think the mother, being the primary caregiver, was actually considered to have been an accomplice by virtue of the mother wanting to conceal and hide the crime. You see, but I'm not sure whether the father does not live with them, or maybe the court was blinded by the fact that it wanted to go for the father as the rapist and actually overlook the fact that they could both be implicated here as primary caregivers and accomplices, and then only then say who then has raped. You know.
No, it is a very interesting one, and I'm glad that you mentioned the father and the possibility of him being the rapist. We're actually joined by legal expert Paul Ngubeni on this one. Paul, thank you very much for your time. You know, it's encouraging to have the department coming on board and saying they want justice for baby M, but today already we had the NPA reining them in to say we didn't find any evidence to that effect. If you're going to name baby M's father as the rapist, it's problematic. What's your take on the statement by the department?
Well, it is problematic in the sense that the agency that has a constitutional duty to prosecute in cases where crimes have been committed is the National Prosecution Authority. And when a department, one would have to say that even if they are overzealous, it's a good thing that they are acting to protect children, or they are urging the public to be sensitive to that. But naming people as criminal suspects, I think they might have overstepped the line there, because if the NPA has not made that pronouncement, it's not clear how the department, a social development department, could claim to be in a better position to make those kinds of pronouncements about someone's criminal liability or wrongdoing.
Mm-hmm. No, certainly we'll have to get the department to at least tell us if maybe they are privy to other information that we aren't. But beyond this, the charge itself or the sentencing for the mother, she's got life imprisonment for aiding and abetting. And this is purely based on her insisting that the child was hurt. What is your take on that sentencing or charge itself?
Well, you see, I'm not familiar with all the facts surrounding circumstances and facts that came out in evidence before the court. So, based on just what I know about the case is what I've read from newspaper accounts. And what remains to me unclear is how the mother could be convicted of a horrendous crime of this nature when the alleged rapist has not yet been found guilty of that offense. I don't want to be to prolong my comments here, because I know you don't have time, but there is something disturbing about the way in which the court allegedly went about finding this person guilty.
Mm-hmm. All the more reason why we want to engage you for longer on this one, because to us it's like a precedent-setting case here, because we don't have a rapist as yet, but we do have a primary caregiver who is now being charged, found guilty and sentenced. So in that respect, we take it that in most cases for parents, this would say you have got to always look at your child, you've got to examine your child, and you've got to be present constantly. But I'm still also a bit troubled around the legalities thereof. So feel free to expand really on your take of how this matter was handled.
Well, there is a problem there. While in our zeal to do justice and to protect children, our judicial system might have actually been overly hasty in terms of finding this woman guilty, based on the mere fact that she said that the child fell, that the child's injuries were due to a fall. And upon being examined by doctors, the doctors then determined that the child was indeed raped. Now, the question of whether the mother knew of the rape and knew who the rapist was, that is not altogether clear from at least the newspaper accounts that I've read. It's not altogether clear that the mother would have been in a position to know all those, to know the exact identity of the rapist, to know that the child was indeed raped, as opposed to the child just being hurt. There's something troubling about it, and I think if she pursues an appeal in the matter, we may very well get a surprising outcome where she might actually succeed on appeal. It's a case that has some very disturbing twist to it. Let me just put it that way.
Now, Memokhale, perhaps to bring it to you.
It's unusual to have that type of outcome where a person is convicted of aiding and abetting or a rape when the rapist has not yet been identified.
No, perhaps let me just bring it back in studio with you, Memokhale. I mean, it wouldn't be, as a commission, it's not far-fetched, at least for you guys. You've seen cases such as these where a mother would perhaps conceal the rapist, but for various reasons. Sometimes it's because they themselves are scared of the rapist. It is a husband. This person supports them financially. So such an instance, I'm sure you're quite familiar with it nevertheless.
Yes, we are. It actually is very common in situations where there is a certain level of abuse, be it physical or sexual, within the family or a close-knit community, that people close rank and do not talk about that. But I think the groundbreaking aspect of this judgment is that finally the accessory and the accomplice and those who aid and abet are being put firmly near the perpetrator, which was one of the things that was a strength about the Sexual Offences and Related Matters Act, because it goes beyond the two people. It goes beyond the old definition of penetration of one's vagina with one's penis. It goes to other parts of the body. It goes to other people who incite a sexual offense. So that act has been very progressive, but it has been on paper. And now finally, I think it is being applied to say the act says we should go beyond.
So it will never be enough now. In today, rather, it will never be enough to say this man is looking after the family, where you think you will speak to your daughter privately if she was abused and say you want to start trouble in the household, let's leave this. The deterrent will then be, if it wasn't before that you just loved your child, the deterrent will be prison term.
Yes, and it would actually be not only am I trying to conceal a crime, but I'm aiding and abetting. You know, and when you hear about it afterwards, now I am an accessory to this. I need to report it.
No, it remains the most interesting case of our time right now, and very unfortunate for baby M. I mean, what that child has been through is quite disturbing. But thank you very much to the both of you for joining us this evening. More news and updates on the other side of this break.